Thank Mr. Conroy.
Well, the other night when the Prime Minister was seen on television to say that he was, or the government was planning to decriminalize marijuana, the reaction from the $500 a plate dinner crowd was one of clapping and some cheering. And he then seemed to feign surprise at this reaction. And as I recall his comments, he then said, "Don't start smoking yet," to which they all laughed again, or "Don't start smoking now," or words to that effect. But I think the reaction from the crowd points you to the fact that to that crowd, and in my submission to many other Canadians, the law is a bit of a joke. And they don't look upon it as serious. And we have heard all these statements over and over again of them heading towards the position that the appellants are taking here, not in the opposite direction. And I think Mr. Burstein was trying to point you to all of these studies that have occurred going back to 1897, in which every Royal Commission that's looked into this in any detail has come to those conclusions. I'm mindful of what the court said to Mr. Burstein in terms of the facts. My recollection, my submission with respect to the facts below is that all three judges in the BC Court of Appeal and then in the Ontario Court of Appeal agreed that there is no serious, substantial, significant, or even large risk of harm to others or society as a whole from the possession and use of cannabis. That the risk to society is more than trivial or insignificant. That the harm principle is a principle of fundamental justice, and that Section 7 is engaged because of the threat to liberty. The specific findings of fact, as my submission were, that 90% of the users of cannabis were low, occasional, moderate users, and that there was no risk of harm to their health whatsoever, absent some pre-existing lung condition or something of that kind. The remaining 10% were the chronic users, and that these were people who smoked one or more marijuana cigarettes per day, and that the risk of harm to them was ultimately they'd get chronic bronchitis. Then there were the three vulnerable groups: immature youths, which is the historically well-known group of people that we protect, pregnant women was the other group, and the mentally ill, particularly paranoid schizophrenics, because of a possibility of precipitating that mental illness if there was a history of it in the family. And finally, the only other potential harm identified was the driving question, which, as we've submitted, is taken care of by the section of the code dealing with one's ability to drive being impaired by alcohol or a drug. The only other, the evidence in my submission with respect to harm to society or to others was in relation to in my submission, speculation that if legalization was to occur, if the drug became freely available, that then, yes, one could anticipate that there might be an increase in use. And I agree, though, with Mr. Burstein that the evidence, as I recall, was that rates of use have gone up and down regardless of what the law says, and that it hasn't been keyed on the penalties being increased, thereby reducing demand or reducing use. But the court below said that certainly there may be more chronic users, there may be more youths that become chronic users and so on. That's the risk to society. And in the past, in my submission, this court has drawn a line between harm to the user, harm to one as an individual, as opposed to harm to others or to society as a whole. And if the harm to society as a whole stems from the user in the sense that there's more and more users and ultimately that becomes a burden on the healthcare system or something of that nature, well, then normally those would be clearly the type of factors that you'd look at under Section 1 of the Charter and not under Section 7 in the balancing that now goes on under Section 7. The court below, I should also add My submissions with respect to the facts below that were made at trial, I managed to get around the 40-page rule by Mr. Malmo-Levine handing up the submissions I made at trial as Exhibit 3 in his proceedings. So you have my detailed submission with respect to the facts in Caine, at least, set out in Volume 1 of his volume starting at page 69. Obviously, Section 7 is engaged in these proceedings because the appellant is charged with a criminal offense, and that's been clear in the decision of this Court, the Motor Vehicle Act reference. The harm principle that we submitted is a principle of fundamental justice in issue. Never necessarily involves some balancing of the interests under Section 7 as opposed to under Section 1. It used to be this Court took the position that if there was a breach under Section 7, you never went to Section 1, but in more recent times, the Court has engaged in a balancing under Section 7. And I'd like to just speak to that issue right now, if I may, because it's my submission that that's one of the problems in this appeal. When I accept, as the Court has said in Mills and other cases, the onus of proof is on the claimant who's asserting that a charter right has been violated. But when you have freedom of speech, for example, or freedom of expression such as in R.J.R. MacDonald, it's very easy to establish that conveying a meaning or limiting the conveying of expression amounted to a violation of Section 2B, and immediately the onus shifted to the government to demonstrably justify the limitation under Section 1. When you're involved with Section 7, the problem is that there's this additional hurdle in terms of the principles of fundamental justice, and what are they? And in my submission, all that should be required of a claimant in relation to Section 7 is to establish that liberty is threatened or that the security of the person is threatened, and perhaps to identify the principle of fundamental justice that's an issue. Because otherwise, you're making it harder for somebody who says their liberty is threatened to establish the breach. They can clearly establish the liberty interest or the security of the person interest, but as in this case, if the harm principle is the principle of fundamental justice that's identified, then what you're asking the claimants to do is to not only establish the breach of liberty, but to also prove that there's a lack of harm, instead of putting the onus on the party that says there's harm, that is imposing the restriction on liberty, namely the government. Surely the government, if it says that the possession and use of marijuana is a problem, should bear the burden of proving that. So the onus in my submission under Section 7 shouldn't just be a blanket onus that you have to prove the threat to liberty and the security of the person, and that it isn't in accordance with principles of fundamental justice. The onus should shift at some point to the Crown respondent to establish the harm. And because the Court started to bring in Section 1 principles into Section 7 in the balancing process, in my submission it's appropriate to bring in that onus of proof criteria from Section 1 as well when you're faced with that type of a circumstance where harm is the central question in issue. And so the onus of my submission should shift, and if it does shift, then many of the questions that you were throwing at Mr. Burstein in my submission can be answered in the context of the different criteria under Section 1 that normally the government has to prove, that there's a pressing and substantial interest to warrant overriding a charter right, that there's a rational connection.
That would mean then that in any of the criminal code or regulatory prohibition, case would start by the Crown having to defend satisfaction.
Well, that's what happens when it's that's what happens when it's freedom of expression. As soon as the appellant shows, or the party whose freedom of expression shows that their expression has been limited, which is an easy thing to adduce, the onus shifts to the Crown. Why shouldn't?
Very specific interest being protected. What you're doing is in place of that very specific speech value, you're saying that any punishment automatically tilts you into
I'm saying any threat to liberty, not just punishment.
anything that carries a imprisonment is a
Right.
threat to liberty.
Or I would include if the decision is one of personal fundamental personal importance, such as a decision as to what to put in your body or not.
Well, so is free speech. I mean, in a sense, it's a liberty interest. So why should we have a different rule for Section 7 than we have for free speech? It's very fundamental that we have free speech.
Well, I'm saying that your rule should be substantially the same as the rule that you do apply in relation to free speech. I'm saying that when liberty is threatened, or the security of the person, or both, that then if the harm principle is the identified principle, the onus should shift. Why shouldn't the government be required to justify every offense that they create that threatens liberty? Surely that's a function for this court. Many of the offenses are easy to justify in terms of harm and so on, but when you get onto the margins of liberty, such as this fact pattern before you, in my submission, he who asserts that there's harm should bear that burden.
I guess isn't part of the answer is that the Constitution hasn't said as much. The Constitution is spoken in terms of no denial of life, liberty, security of the person, except in accordance with principles of fundamental justice. So the nature of the protected right has been expressed in those terms, just as unreasonable search and seizure has been expressed in terms of an unreasonable search and seizure. Does the citizen the citizen has to identify the unreasonable search and seizure? He or she has to demonstrate that.
Yes, my submission is surely it should be sufficient for a claimant under Section 7 to show that their liberty is threatened, to show that the security of their person is threatened, and to identify the principle of fundamental justice in issue, and at least perhaps a prima facie case. But again, if
well, that's a different thing from saying, that's a different matter from saying, and once you're saying that, if your argument is that you have to show the prima facie case, well, that's a different matter. Well, I didn't hear you say that at the beginning of your argument.
Well, I mean, the problem in my submission is that if you look at the whole framework of the Charter, the fact is that Section 1 says that the government has to demonstrably justify that it's a reasonable limit on the Charter right. By forcing the appellant to prove under Section 7, in addition, that there is no harm from their conduct, to prove a negative, you're putting an additional onus on the claimant under Section 7. Surely the framework of the Charter allows for the balancing situation to occur with the government having to justify the reasonable limit, having to justify the lack or the existence of sufficient harm to warrant the use of the criminal law power. This Court, prior to the Charter, used that test. In my factum, I set out the paragraph from Labatt Breweries, and in